me get started here. And today we're going to talk about how to protect your loved ones and why estate planning can't wait. So I want to welcome you to Real Estate Investing Made Simple with LeAnn Riley. And we do live interviews monthly with experts and leaders in real estate investing nationally. And I'm LeAnn Riley. I'm a national real estate coach and a broker, and I help ambitious, high-performing people build a personal roadmap to wealth with real estate investing through our proven profit formula. It's a system to find winning cash flow properties. I built a $14 million portfolio in residential, multifamily, condo development, commercial, and vacation properties. Love those vacation properties. I lead the Encore investment team of realtors in the Twin Cities, Minnesota, and you can call us to buy, sell, or invest. And don't miss out on the investing how-tos and education, and that's over on my YouTube channel. These interviews, they go over there, so you can look up a lot of subjects, because I have been interviewing people for probably about 4 or 5 years. So there's a lot of good data over there. So don't forget, and if you're over there, subscribe. So today's topic again is really about estate planning. There's so darn many questions. I see we got a couple realtors on here. And today, let me introduce my guest. It's Sarah Breiner. Is that the correct?
Breiner, that is correct.
Ooh, I had to guess.
Thank you.
Okay. And Sarah's practice ensures the safeguarding of your family through estate and small business planning. And Sarah will help guide you to create a plan that continues to work for you and your family throughout your lifetime, because as we all know, shit happens, right? And Sarah is licensed in Georgia, Minnesota, Kansas, and Missouri. She spent a few years in private practice, and then she became associate in-house counsel for the Atlanta Habitat for Humanity. Lots of housing issues there, I bet.
Oh, yes.
In 2007, she accepted a position practicing real estate, creditors' rights, and compliance, and became one of the youngest named partners. Next, Sarah opened Breiner Law Firm with a focus on helping families, and the Eden Prairie office was added in 2018. She goes by the Legal Mama, and that's a lawyer with heart and the drive to make a difference. So right away when I read that, I'm like, I like this lady. Sarah prides herself on simplifying the client process, and it's through a series of innovative client packages and memberships. I really like that method. And you'll never be left on your own to figure things out. And what I hear from all my investors, as life changes, you have new questions. And with her plans, you get to keep asking. You don't have to, pay every single darn time. You get on a plan and she's with you as the estate changes. She loves the outdoors, kayaking, hiking, and anything that involves nature. Sarah and her husband, Danny, live with their 2 kids, 2 dogs, and 3 chickens. Do you get eggs?
We do, and we've added a couple ducks since then, so we get duck eggs too.
Ooh, okay, so really glad you could join us today. And I'm going to start with a question. I'm really curious. What's the most common question you get from people about estate planning?
And thank you so much for having me too. I'm really excited about the discussion today, and I'm really passionate about being a resource for other business owners and investors and things like that. So I'm so honored that you thought of me to be able to answer these questions. And yes, there are definitely common estate planning questions I get all the time. I would say hands down, the number one question I get the most is, what is the difference between a will and a trust? And the short answer to that is that wills and trusts They're two pieces of a larger pie that we call the estate plan. So that plan includes your financial durable power of attorney, healthcare directives. Some of the things that we do specific to us are other supplemental documents to make sure that plan is going to continue to work. So emergency guardianship, minor child planning, we have something we call the guardian guide, as well as financial tracking, annual meetings, and things like membership or how you can keep up that plan. But the wills and trusts are two separate documents that make up that whole pie. So without all of the documents working together, you don't have a complete estate plan. But the main difference, I would say, between wills and trusts is how you go through the process when someone passes, whether or not you're going through a litigated court process or you're able to handle that in the privacy of an office, essentially.
And we all know we don't want a litigated court process.
No, we do not.
That's it. And, you know, I can speak to that from 2 divorces. Not a good thing, especially when you own a lot of real estate.
Oh,
So,
yes.
yeah, and I never understood that difference between the will and the estate plan until I was heavy into real estate investing and then realized, oh my gosh, you have to have something in place. But it was so confusing from being the
Yeah.
investment side of, oh my, where do we get the right information on this? That's why I need someone like you. So I know you're about family legacies, and that's so in line. Everybody I talk to about investing, that's why they're doing it. It's
Yeah.
to be able to pass something on to the family. But what I know is if you don't have your ducks in a row with your paperwork, your will, your trust, or however you're going to do that, it what you thought and what you get are 2 different things.
Oh, yeah. Oh, yeah. And I always say too, if you know, there's a number of different kinds of plans you can have. But if you say, well, like, I don't have a plan, the answer is you do have a plan. It's just the government's plan, not your choices, right?
Oh, that is it. And
But yes.
we deal, you know, as realtors and as people are aging, we deal with so many who they're like, oh my, you know, the kids are the ones who call you because mom or dad died or something.
Right.
And then they now are stuck with no plan. And now
Right.
we have to go tell them, oh, you better talk to us. You're going to have to go to probate and we need a certain document before we can list the house. That takes
Yes.
4 months.
At least. We
And
just
we're
had one
planning
case where the property was the only asset, and the elderly woman had was left the house. Title wasn't correct, right? So I'm sure we'll touch on what that should look like, but title was not correct. And so we had to go through probate just so that she could sell the house to live off those proceeds, because it was her only asset in her elder years. And it took almost 22 months before she could sell the property. And that's just how slow the process goes. So it wasn't that anything wasn't being done timely or anything like that. You're just in the queue waiting for the court to get to you, and it's slow as molasses. And when you have, you know, in her case, she had a cash buyer offer, they weren't willing to wait around,
Oh,
you know,
yeah.
so that's heartbreaking.
That is heartbreaking. So let's talk about, you know, how do we set up that plan and what do we have to do? So what's the advice you have for someone just getting started as an investor? Do they need an estate plan? It's their first property.
Biggest key is preparation. So setting up the correct foundation and structure from the beginning is just as important, you know, if not more, than picking the right property that you want to invest in. So, and one thing, like you mentioned, that's so special about real estate investing, it has the potential really, you know, to perform as a lasting legacy longer than any other kind of investment out there. And really, it's one of the best ways to create that financial empire that can go the distance. But if you don't plan correctly from the beginning and have those safeguards in place, then it's not going to last long enough to pass on to anyone. So really, the key thing you need to know when you're getting started is lay the foundation properly. Establish your trusted advisor team when you're getting started before you do anything. So that should be legal, financial as in accounting and tax, and insurance. Those are really your
Those
key
are the 3.
areas what we call lift, legal insurance financial tax. You have to lift your foundation, right? Like you have to have that foundation in place. So whatever comes your way, your structure is going to remain, right? Your structure is going to stay standing.
I love that. Lift, legal. I've never heard that before, but that's
Yes.
exactly what I teach investors. You bet. You better have
That's what
all
I
that.
call it. My colleagues and I, we have some planning things that we do as a group, and that's one of them.
I love it. I love it. For anyone who just joined us, I see there's a couple, that link there in the chat box is to a form. It kind of guides you through what Sarah's going to talk about. So you might want to just pull that up on your computer. So I have a lot of questions that real estate investors ask me, and I'm not a lawyer. So I always say, boy, it could go this way, it could go that way, but you've got to talk to a lawyer or an accountant or whoever, because we're not that. So it's really great to have
Let's do it.
live. So the first question they always ask is, do I need an LLC on this very first property? And,
Hmm.
when does an LLC help or not on your estate?
Sure. Sure. So, how we protect assets from lawsuits and creditors really happens in multiple ways. So, when you have a business, whether it's real estate investing, consulting, you're a real estate agent, you have a brick and mortar, it really doesn't matter. We're all exposed to risk. So, you have to layer your protections. So, one, an LLC will protect, your own personal assets from being available to creditors if you go into debt or you get sued, but only if you operate that LLC and its finances correctly. Yes, you should have an LLC from day one. That's part of that foundation. It will not, though, however, avoid your business getting tied up in probate. An LLC cannot do that for you. And it also, it cannot avoid the requirement of probate in multiple states if you have properties in more than one place. So where you reside when you die is where your probate is filed if you don't have a trust in place. However, additional probates, what we call ancillary probate, will happen in every single state where you own real property. And so you can have, this is what we call double probate, triple probate. You're paying those probate fees in every single one of those states, and every single one of those properties is tied up. If you have an LLC, that is an operation that's going to go through probate if it's not in a trust as well. So step one, create LLC, yes, that will protect your personal assets from being available to creditors. You absolutely must keep your finances and bookkeeping completely separate for each individual real estate LLC, and that holds property. Commingling funds, what we call commingling funds between assets and operations. So expenses, flipping, all that money that goes in and out, rental income, all the different things. If you're commingling those between properties or with your own personal finances, that is how creditors will be able to grab onto your assets or other investments. So I never recommend putting more than one investment property in an individual LLC for that reason. And so that's kind of like layer two, is making sure that you're not only getting the LLC in place, but you are keeping the finances clean and separate. Having an LLC and putting that property doesn't mean you don't need insurance either, right? So insurance is the next layer of that protection. You should be insuring your LLC and the assets in it. You should have your general operating policy, or what we call a BOP, business operations. Sometimes that includes errors and omissions. So if you're agents, I'm sure you know all the things that go into that as well. And also then your property casualty coverage. But insurance also is kind of like the not last piece of the puzzle, but life insurance or key man or partnership insurance is really crucial as well. If you have business partners that you operate with and your partner dies, their interest in your business is now tied up in probate if they don't have things set up properly. So this is where we see, you've got all these investments, properties, and now you're tied into this probate and you cannot operate. So that is the quickest way to essentially choke a business, into failure. And so having life insurance for yourself, for your business, and any partnerships allows you to have that cash flow to buy out a partner or keep it out of that process. And so that it becomes the final piece of the puzzle is your business and all your LLCs should be in a trust. And then your trustee can continue to operate all of your investments, all of your LLCs and businesses if you pass, or if you're incapacitated. And so that allows the properties to continue to operate and the businesses without being tied up in probate and avoiding that essentially catastrophe of your business or investments going under.
So, I was in business with my mother and my sister. We owned a publishing company, and luckily someone taught me that early on, because like if something happened to my sister, I didn't want to be in business with her husband.
Exactly.
Like that. So my dad taught me it early on to get all this settled in the front, get the attorney, and then we did all that, and we never had to use it, but it did help you sleep at night.
Absolutely. And, sometimes if you're, especially with real estate investors, I feel like it's somewhat unique as far as some other services where it's like you may be the face of that operation. You may be, because that's your main source of income, you're doing that day-to-day property management operation and things like that. And if something happens to you, then it may mean a management company has to be hired to manage those investment properties, or someone to replace you in all the work that you do on the day-to-day. But if your operations and the cash flow is tied up in that probate process, where are we getting the money to hire that management company?
Right.
That's where the life insurance comes in.
It does. So I like your lift thing. They're tied together all
Absolutely. Yeah.
Or you have whole.
Yeah.
If you're missing
You're
one.
gonna sink.
Yeah. Now, Tim is asking, do you need an LLC for each property?
Yes.
Yeah.
You'll
Now,
see lots of different answers on Google. In my professional opinion, the answer is 100% yes.
and I have done this. I had one mother company, I call it the umbrella. Could be a corporation or an LLC, and then I had each property. But I did keep one set of books, but it was all separate. Each property had each expense, all that stuff. But I had to see the big picture too.
Yeah, and our concern with that sometimes is, even though they're individual, when it's tied to a parent umbrella like that, it could mean, depending on how it's operating and a million different things, it still can expose those holdings to liability if there aren't enough assets to cover whatever that liability is with one of those. And so the way that we like to structure it is you put an LLC in place for each individual property, and then all of those LLCs go into a trust so that the trust holds those individual liabilities and it won't get tied up in probate. So you're hitting two birds with one stone.
Yeah,
you're avoiding that legal process. There's still limited liability protection, and they're not tied to each other with a parent company.
Yeah, the trust. Yep. Okay, yeah. Now Tim's really got questions. Yeah, are there dangers of owning real estate jointly, husband and wife?
Well, when it comes to owning it jointly, so if the question is, well, there's different ways we title property. So most married couples will have their property owned as joint owners with right of survivorship. And so what that means is that if one passes, the other one automatically now has the entire property. That's all well and good until that survivor passes. Now we're right back in the same boat of, okay, well, what does their planning say to do with the property now when both individuals are gone? And if it's not in trust, it's going through probate. But also, when it's held by you as individuals, it is exposed to any creditor risk or any other risks. They're, one or the other. So you can have one spouse with really good credit, one spouse with bad credit, and they're both jointly owners of that property, it's exposed that way. One misconception we see online or Google or just in different places a lot is that having a trust also gives you asset protection. It depends on what kind of trust you have. You can have a trust set up in a way that will give you full asset protection. And there are trusts that we use day to day that don't give you asset protection. But having joint owner with right of survivorship doesn't fix all your problems, essentially.
You know, I can speak to that with a big portfolio and a not friendly divorce. Minnesota, one to
Yes,
buy, two to sell.
that is correct.
And it
That
didn't
is
matter
correct.
what LLC we had it in or who,
Right.
you know, if he owned that LLC or it was mess. Big
That
mess.
is correct. Right.
Yeah. And you know, that not all states have that one to buy, two to sell,
No, they don't.
but Minnesota does.
Yep.
Yeah.
Yep.
And boy, I found out how I thought I was protected or we had it sorted out and we didn't, just so you know.
Yeah. And there are different ways that we set up planning, both from that LLC or succession planning and also from estate planning for what happens in the event of a divorce, right? Because in a divorce, they'll tell you who gets what, but they don't help you necessarily handle that, the deeding of the property or fixing that subsequently or the mortgages. But also, you know, there's different ways to do planning that you can keep your things separate. So if you're the investor, maybe some of that original investment money came from an inheritance from your family or things like that, or work that you worked hard to do and earn that money before you were in that relationship or whatever that looks like. And so there are ways that we can set up planning so that if you create LLCs or have an investment property or properties in your name and you're doing that separate from your spouse and you want to keep it separate from your spouse, we have ways to do that in estate planning as well to keep it separate.
Yeah. And like I said, I thought I had it organized and it
Yeah.
was, you know, not the way I thought it was. So, okay, Tim had one more. Thinking of a personal residence does not holding the property jointly then expose both husband and wife. So in other words, if one person owns it, I believe that's what he's asking, or a single member LLC owns it.
If not holding the property jointly, does it expose both husband and wife? So if you have one spouse who owns title to the property and the other spouse were to get sued, I get, so maybe like physicians have malpractice risk or things like that. Minnesota is not a community property state like Wisconsin is. So if one spouse gets sued, that does not mean it's the other spouse's debt. So some people think that if I have it only in one spouse's name, then it won't expose me. But it really depends on how everything else falls into the picture because yes, it may keep that one asset from a creditor coming after the other spouse. If they're not on the title, it may protect that asset. However, I get asked the question all the time similarly of, if one spouse has debt of whatever kind, mortgages on investments, medical debt, and they pass, does that mean the other spouse is responsible for that debt? On paper, it doesn't mean they can sue the other spouse in their name for those debts. Does it mean that they have to get paid before the spouse or any other beneficiaries are getting their money out of that estate? Yes. So it all comes out of the same pot, right? So sometimes we're not seeing the forest for the trees, that it's not necessarily one little asset here or there. It's making sure the entire plan is protecting the family estate and assets.
I
So we
love
look at all of that, we
yeah.
look at all the big picture when we're assessing that.
This is a bigger picture. It's not
Yeah.
just this piece or that piece. You're right. And how about this? You say you're going to flip a property, you know, and it's a short term. It's going to all happen in
Mm-hmm.
8 months. Do you need to put that in an LLC?
There's a couple different ways you can do it when you're flipping. So if we're looking at it from the estate planning lens of what happens if something happens to me while I have this property in flux, then when we set up trusts and they're set up properly, you can close the name of the property into the trust, because sometimes it's not necessarily the LLC limited liability exposure that we're thinking about in these short-term flips. Some investors, of course, can buy for cash and things like that. But if you do need financing, or you want favorable terms to get those properties that you're going to be flipping, there's often better financing options available if it's a personal loan versus a commercial loan, right?
Yes.
And
Yes.
you're tied to all of the restrictions of a commercial loan. So sometimes it makes more sense. You've got your trust set up. I always talk about your trust. You mentioned you watched one of my webinars. We always talk about your trust as your little red wagon. If you think of, you say, I want to have a trust created. You're buying a wagon. The wagon is empty when you buy it. Everything you put into that wagon, all of your assets during your lifetime, bypass that legal probate process. And the beauty of the wagon is once the legal documents are in place and signed, you can take things in and out of the wagon as much as you want. You can move the wagon around from place to place where you go, and the assets can come in and out. So as long as you need to do that, when your trust gets set up, then every one of those properties you purchase to flip, you close it in the name of the trust. And then once it comes out, it's done. And as long as if your concern is the liability exposure, then you have to make sure you have the proper kind of trust set up to give you that asset protection while those assets are in there, but that they can come in and out. So you can purchase a property, close in the name of the trust, fix it up, sell it out of the trust, and you're done.
In your webinar, I loved this. She had a picture of the wagon, but a lot of people get the wagon, the truck,
Yes,
but then they forget to put the contents in the wagon.
correct. It is the number one way that you can lose real estate when someone dies. And real estate is the number one type of asset that is most quickly lost when someone dies, and it's not either in a trust or, like you said, you created a trust. I can't tell you how many clients, or it's usually the adult children, right, that come in and say, I have a parent that passed. They had a trust, so we can handle that now and we don't have to go through probate, right? And my first question is, well, where is the list of assets that shows what's in the trust, and where is the title documentation to all of those assets? And it's usually like deer in headlights, because it just isn't part of the standard process. So, as when I was coming up as a baby lawyer and I was learning all these things, I would learn how all of these firms historically or traditionally would do the estate planning process. And I kept saying over and over again, but isn't that malpractice? Like, why are they not making sure that the assets are getting into the trust properly? Nope, that's the way we do it. That is the accepted common practice. And it's like, that's all well and good, but that doesn't mean it's the proper practice for clients, right? It's not in the best interest. And so that is one of the things we focus on very specifically. It is like phase 2 of the process is, yeah, getting the documents in place and signed and figuring out what structure we need is step 1. Step 2 is making sure it gets into your wagon, or else you've paid for a plan that isn't going to actually function or do anything. And, that it's not going to give you any protection in any aspect, but getting those assets into there. So we usually utilize a quitclaim deed to move property from your name personally into the name of the trust. If you have the property in an LLC, then we use a document that's an assignment of the LLC interest into the trust. And that allows whoever is acting as your trustee to do whatever they need to do with those properties. So if you're in the middle of a flip and you die, that trustee can step in and finish that process and sell the property. And then those proceeds will go back into the trust for either the ongoing operation that's going to continue as part of that legacy, like we were talking about, or it may mean your beneficiaries, your heirs, your children, whoever that is, wants to sell that property and take those proceeds and do something else with them.
And, does it affect your taxation if things are sitting there in the wagon? That doesn't.
Yes, it will positively impact taxation. So the biggest tax protection we see are 2. One is estate tax. And a lot of people will say, well, I don't have enough money to owe estate tax. Well, Minnesota specifically, and I know we have people nationally here today, but Minnesota specifically is a very low tax threshold. So we are looking at, to start, the market value of all of those properties and assets that you have in your portfolio, as well as face values of life insurance, retirement, all these things that we don't even have the full benefit of that equity during our lifetime, right? Because it's tied up. But when you pass, all of that is counted towards estate tax. So in Minnesota specifically, when we use trust planning, you are able to double your tax exemption limit right off the bat from having the proper tax trust in place. So that's huge. You go from being able to have $3 million in assets to $6 million if you're married. You can't do that outside of trust planning in Minnesota. Nationally, with IRS or federally, right now the limit is very high because you have essentially 25 million you can have as a married couple in assets before you're paying estate tax. However, that's about to sunset and revert back to what it previously was, which we don't know exactly what the number is going to be. Anywhere between 5 and 7 million is our estimation, but we won't know till 2025 for sure, depending on if anything happens with legislation. And then you're right there really quickly. You have a couple of commercial properties, or you are likely in that realm of estate tax. Most importantly, I would say in some ways, is capital gains tax. So when you have a trust in place, you have capital gains tax savings and protections you do not have from an LLC alone, or for those assets being in your personal name. So when you have a trust, if you pass, you receive a step up in basis for all of the property that's in that trust. So what that means is, instead of the base purchase price of what you originally purchased that property for, it comes up to the market value in the date of death. And so if then that property is sold in that same market value, or in that same market, so like your beneficiary inherits property from you and then they turn around and sell it once they get it, they won't be paying that capital gains on that increase. That could be tens or hundreds of thousands of dollars very quickly. It wipes it out.
And that's
a lot of the time.
That's what the
huge.
wealthy do. That's what the wealthy do. It's all in a trust, and then the kids can take care of the trust and they don't get exactly.
Oh yeah.
This is how you preserve the wealth.
And this is what I always say too, this should be available, this knowledge should be available to everyone, not just the uber wealthy. We should all have the opportunity to not only make these investments, but actually to utilize these tools as well.
Because they do make a difference. I mean, if you're building a legacy for your family the whole time and you don't have it in order, this could just blow up. And they could lose a lot of what would have been something that go to the family.
Yeah, I mean, I had a family, two adult children that came to me last year, and they were so excited because they were like, we've lost our elderly parents. However, they have had a house at 50th and France for 30 plus years, and we just know that's going to be worth millions now. And so they thought they were going to end up with millions of dollars, right? Because that is a hot commodity. And turns out, it was in their name. It wasn't in a trust. And because they had it 30, 40 years, they paid, I think it was like $32,000 for the home. And now it's worth 1.2, and they're paying the capital gains on that.
Yeah, that's a lot.
So there goes the profit, right? So if that had been in trust, they would have gotten all of that. Huge difference.
Huge, huge, huge. And when you said there's more than one kind of trust now, the family trust, that's different, or you take everyone's situation depending on what's in the wagon, and then you decide what kind of trust.
What we create happens at the beginning. So the structure of trust is how it's drafted. And there are two main categories of trust. So family trust is a little bit of a confusing designation. We actually refer to them as revocable living trust.
Oh, yeah.
When you hear family trust, yes, it is your trust you're setting up for your family. However, if I see that they have a living trust, that means the people that created that trust and have their assets are still alive. If I see family trust, that likely means it is converted from a living trust to be that remaining trust that is going to be in the ongoing there for the ongoing, however long it's set up to operate. Now it's a family trust. So revocable living trust are the general starter place where we go when we say, okay, we need a trust. A revocable living trust is what is going to allow you to put all of your money into your wagon, but continue to control your assets and have the benefit of utilizing them. Because it doesn't do most of us any good if we take all our assets and put them into a wagon that we don't get to touch anymore or live off of. We need that money. We need that revenue to live off of, right? Once we've passed and we've passed it on to our heirs or beneficiaries, now it can be a permanent trust where they may not get access to it all at once, because a lot of the strategy here isn't just protecting those assets from risk while we're alive and operating it. How do we protect that inheritance from risk of our beneficiaries so that it can also last, right? It can last multiple generations if it's set up in a way that it will protect from any of their creditors, or if they inherit this asset or this empire and then they go through a divorce or things like that, this is how we lose inheritance as well. So revocable living trust, there are 5 or 6 that I create on any given day for any client, and it is very specific to their assets and needs as to which one of those structures we create. So we evaluate that at the time we review assets.
This is complicated. I mean, like to the, and I know a lot about real estate and all, and I've had trusts.
Yeah.
And yet I'm like, I really understand how we need somebody who gets it. That's why I picked Sarah, someone who's been in real estate through the trenches. Then you understand what in a typical investor buying 2 or 3 properties, they don't get any of this. So we need our team, folks, and people, we need, just like her lift, we need all those 4 people, and they kind of have to work together in some ways, because sometimes I hate it when the accountant says, well, you better go ask your legal team, and sometimes that's hard because I can't even express the question correctly. So I'm not sure what I'm asking my legal.
Sometimes we don't know what we don't know, right? And that's okay.
This is complicated. So let's see, we got a couple more questions, something about depreciation on, let's see, what's that? Can you only take advantage of bonus depreciation on business assets like vehicles and equipment?
That's a tax question. That's a CPA
question. Yeah, that's
question.
A tax. I didn't think that was us. Does the trustee of a revocable living trust change the trust later?
Depends on how you set it up. That's one of those like 6 different types. I mean, you can allow your trustee to change it or not change it, and depending on what you want the outcome to be. So for instance, if you're a married couple and you pass and you leave your spouse with all of the assets, it doesn't really matter what age you are, but you say, okay, well, if I'm gone, I still want my spouse to be able to live on and have money to do that, or continue to raise children or support the family, all of those things. But that also means you're leaving your surviving spouse at risk, and you're leaving the estate at risk, in the sense of, not saying you don't trust your spouse to do the right thing or whatever, but the likelihood is that spouse may get remarried, that spouse may have a blended family, that spouse may have future creditor issues, or you're leaving everything in one bucket in their name that will make sure that they will never be eligible for things like Medicaid, right? And so what the spouse does during the remainder of their life impacts what's left in the estate, for sure, right? So we have the ability to set up trusts in a way that when the first spouse passes, we take half of that estate and we essentially set it aside and protect it and give it asset protection. Surviving spouse can get remarried. Sometimes they want to include stepkids or other people in their, new plan. So when we create a living trust for a married couple, they're both trustees usually in the beginning, and the survivor remains a trustee. So one of the questions we ask when we're designing plans is, if you pass, do you want your surviving spouse to be able to go redo this whole plan that you've done, change all the beneficiaries, or leave assets to new spouses? This is obviously where we see, aging parents that go and get remarried, and then the adult children are like, they're a gold digger, like, you know, like those kind of things. There are ways to structure it so they still have the income and support for their elder years or their ongoing life, but also sets aside assets in a way that it can't be taken if they go and marry someone new and then go through a divorce. Or, I mean, we can go down the rabbit hole of hypotheticals, right? They get remarried, they're the first to pass of that marriage, and now we have some other person that now has the whole estate, and maybe they have adult children that are now out of, like, getting disinherited, things like that. So there's so many hypotheticals and scenarios that we go through to say, do you want either your surviving spouse or anyone else acting as a trustee for you to be able to change the terms of this trust? Or do you want to say, I don't want anyone ever to be able to take anything away from the beneficiaries I'm setting this up for? And there's all kinds of things in between, because sometimes we say we want trustees to be able to amend the trust if there's a need to, say, gift under tax rules or move things around in a way that will avoid any kind of tax implications or things that may not have been on the books when we created it. So there are benefits to letting them amend things, and there's risks to doing that too. So we have to hash that out.
I have a question here. Was talking to someone today actually, and they nice family trust all set up. You know, dad died already. Mom has dementia.
Mm.
And there's the woman I was talking to has power of attorney with the trust. Her and her sister do. Can someone change it? She better look at her trust papers, huh?
If the power of attorney document specifically says that the trustee or that the power of attorney can amend the trust, then they probably can. So that's when we go back to that conversation of, this is, each of these things is one piece of a puzzle, of a pie. So your financial power of attorney needs to correspond to your trust.
Oh, they got to
So
go
if
together.
you make a design that says, I don't want anybody to change this after I'm gone, even a surviving spouse, I want it to be secure in this way. And then you go online and download a power of attorney form, and and you don't realize that it says, well, the power of attorney can amend the trust. Now you have, you know, conflicting rules. Yeah. So
wow. And also, like in this particular situation, there's family members, you know, there's other brothers and sisters. They're not power of attorney or executor. Can they change it?
No, unless you are a trustee given the power and authority to do that, no.
Or the
just because you're a
paperwork's not.
beneficiary doesn't mean you
Yeah.
can't change the rules.
Well, and I run into this when I list houses, you know, elderly people, they have some dementia. And what we know as realtors, you know, they can't really sign legal documents, you know, because
Right.
you know, so then I tell the family, you need to have power of attorney. And this happened in my own family when I was married. They didn't take, they had a huge estate, this family. In fact, she was in charge of two other people's estates who had died. It was a like total mess. And waited till too late. I had two attorneys there. She's laying on the gurney, and they deemed it that she can't make this decision. So the whole thing was a 5-year mess. Yeah, and it was so sad. But that dementia is quite a thing. That how do you determine when? And like I said, they had two attorneys there to determine whether this was going to be valid or not, what she signed.
And that also tells me too that there's something missing in the estate plan documents, because when we draft trusts and wills, there are specific guidelines in there that define when they're considered capable and when they're not, and what requirements we need to show that they're no longer capable. Like, let's say, you know, the family says they can't handle this anymore. We need another person to come in as the trustee and manage it for them. We have to show that they really can't. And so if you don't have a definition around what is required to prove that under the documents, then it's a gray area as well, or can cause problems.
This, you know, really, I mean, folks, this is planning your life. and not leaving a mess, because I also have sold many houses where, somebody died and it's a total disaster for the children because none of them are capable of working with attorneys or figuring out the mess that was left. They forgot to
Yeah.
put a beneficiary on a pretty big ordeal on that last one. And yeah, selling the house is murder when you don't have the ducks in a row.
Yeah. And, kind of going back to that conversation of like, what is a family trust? Like, why do we do that? Regardless of what we call it, the whole point of the trust itself is that it's a will substitute, because wills go through probate, trusts don't. And so if we talk about the question of like, well, why do we want to avoid probate so bad? Okay, it's you have to file paperwork, it takes some time, but like, okay. The answer to that is there are a number of reasons we don't like probate. One, it's public. That means that every single asset you own is public record. Every single beneficiary, their age, their home address, when they get that asset, all public record. You can Google that. If you have all of this property out there, now someone knows that the person owned it has died, and there may be exposure there of like the family just wanting to unload things or not knowing the value yet of things and trying to take advantage of that. Then there's the cost that goes into probate. So if you take a minute and say, okay, what is the market value of all of my assets in my real estate investing portfolio? And then all those other things we talked about, the value of my retirement, face value of life insurance, brokerage accounts, everything you have, if you put it into one pot and look at the market value, generally the cost of going through probate will be about 2% of that. So if you just look at the value of your current real estate assets and say, do I want 2% of that to go to the government, or do I want it to go to my beneficiaries, right? And the other piece of that is that instantaneous access to money. If you have all the overhead of that operation and management, and now we have to have cash flow to pay for these things, you don't want your beneficiaries having to liquidate those assets to cover the cost of them.
Yeah.
And now there goes your legacy, right?
Well, and they have to go through the time and the trouble of liquidating real estate isn't the easiest thing on earth.
Absolutely.
It really isn't. Okay, but
Especially if they're not in the world of real estate, like everyone here, right?
right. People here are in the world, but without being in it, you're in the dark. And lots of times the kids live in a whole different state. They don't even, they
Mm-hmm.
haven't been to the house in a lot of years, and now it needs fixing, and good God. Yeah.
Yeah.
I have another question before we hit these other ones, because this happens. I get a lot of people like this. That whole thing about the 5-year look back on the,
Mm-hmm.
they're aging out and they're trying to do this Medicare planning, or
Right.
what do you do about that? Like, does the trust take care of all that if you did it at least 5 years before someone got sick or dementia or
Mm-hmm. Revocable living trusts do not protect against that. Though anything in a revocable living trust is counted against your assets for Medicare, government benefits, anything. So instead of revocable trusts where you maintain control over your assets and can live off of them, this is the tricky thing about Medicare planning or elder care planning. Not only do you have to do it at least 5 years before you're trying to, qualify, anything that is transferred out of your name somewhere else to hold it or protect it against those claims can be pulled back, or so that's they can look back, or what we call clawing back. Medicare can claw back those assets within a 5-year window if you have moved them to essentially hide them from the government. So the tool or the container we put them in is an irrevocable trust.
Okay,
the difference between a revocable and an irrevocable is just one, as it sounds, you cannot change it once it's in place, even if you're the one who created it. And also, most importantly, you are not the trustee. You do not have control over those assets, and you don't get to choose when you get to use them either. So someone else besides you has to act as the trustee. and manage those assets. Now, in the digital age, that doesn't mean people aren't logging into accounts and looking at what's going on and things like that. But if a trustee is buying and selling flipped property or investment property or moving things around or doing any of that administrative work, it's a trustee that is not you that's having to do that work. And so pro side of it is you've moved it out of your estate for both estate tax and taxable reasons, and it can no longer be counted for things like Medicaid. However, you're turning over control of that to someone else. So it has to be someone that you trust.
And
they're very expensive to create.
oh, okay. But that could be the law firm or somebody you're not even, or is it you
can use what we call a corporate trustee. If you're like, I don't want family involved in this, no one will agree, or it'll cause issues, or I don't trust anyone, whatever that, or I don't have anyone, then you can hire what we call corporate trustees. That can be a trust department at a bank or an agency that just does that. Certain law firms do that. Yeah.
Okay. That answered somebody's question there.
Yes. And if you want to know what the fees look like for a corporate trustee, it's usually about 1.5% per year of the trust they're assets in the trust they're managing.
It's not cheap.
No. But sometimes it's worth it, right? Because it may be the difference. Like if you get above estate tax limits and there are no more tools we have in our toolbox on the revocable side or other gifting and tax planning, then our next step is to look at irrevocable trust to move that property portfolio into.
Wow. You know, this just these questions today makes it, and your answers, it's like
it really shines a light on it, right?
It scares you in the sense of I better be working with someone who really understands this. And this is where going to the internet and looking up family trust and thinking you can print a document and having it all tied together in the wagon properly is pretty unrealistic. Because
I would agree.
Just even knowing the difference between revocable and you're going to sign up for what you want. And I remember when I had a trust until the divorce, then we dissolved the trust.
Yeah.
And I remember when I was setting it up, and between the insurance guy with that being correct and the trust, I didn't understand it. Irrevocable, all that. I was like, whatever they were advising, I was like, okay, I guess this is what we're going to do. I did not get it. And
yeah,
you do have to find people where you trust, because that's your gig. You know it all day long, just like me in real estate. We have to trust the team we put together. And that's why I like your plan, Sarah, where, it's not just we go there one time, you get it all together. Then we have questions next year because we bought another property or whatever,
right.
We can call you and make sure that it fits in the wagon right.
Absolutely. And what I experienced for so many years, I was a partner at a law firm that I wasn't an equity or voting partner. So I didn't get a say in like how we did certain things, but I was responsible for that process. Right. And what I would experience over and over and over again is that I would find out years later when the family came to me to essentially execute and put that plan into place, the person had died, that, they went down to the bank. We gave them instructions to say, this needs to get into the trust. And the bank didn't understand because there's a lot of turnover, or they're not in the trust department or whatever. And, one of the spouses would say, well, I told them to call you. And then their answer is, well, she bills at $500 an hour, not my choice. Right. And we're not going to call her and ask a 5-minute question. That's going to be $100-something bill in the mail. So forget it. And they leave the bank and they never go back, and it doesn't end up in the trust. So when I opened my practice, that was one of the key things. As I said, communication is key. Questions are important for a reason. I don't want anyone to ever be hindered from calling and asking questions so that it gets done correctly the first time, and you're not having to like take more time off of work to go make an appointment at the bank and all of those things. And so that's why we do the flat fee planning. It's like, I don't care if it's 10 years from now and you move from your personal residence to another one and you're like, I know it was in the trust, there's something we're supposed to do with the trust, I don't remember what it is. I'm like, I don't care you paid for your plan 10 years ago. I want you to call me, because I would rather walk you through it or talk to the title company now and make sure that it gets handled properly and you don't end up, or your family doesn't end up in a mess when you're gone because it didn't get worked out because you didn't want to pay for more attorney time. And I understand that. So yeah, we always have unlimited communication because there's always going to be questions. That is life. And your plan isn't going to
There is.
function unless you get those things sorted correctly.
This is so good. We're going to go a little bit over, but I got to ask you, I got a couple more questions. I noticed that you also do business succession, and real estate
Mm-hmm.
have that because, they're aging out or whatever, and maybe your kids are going to take over or somebody. Is there a bunch of options in that world too?
Yes. So we look at that both from the LIFT planning, the legal, insurance, financial, tax. Legal includes business succession planning and documents. So within your business, your succession plan should show up in your operating or partnership agreements. But that doesn't happen a lot of the time because either you're the only partner or member of your LLC or plan. So you think, well, I don't need that. And then there's no rules or instructions for anyone to follow of what is supposed to happen to the business if something happens to you. So we refer to that as exit planning, but that may be a voluntary exit or an involuntary exit because you exit the world. We don't know what that could be. So you should always have an operating agreement, even if you're the only owner of the business. And if you are in a partnership, we kind of touched on this a little bit, that you need to have an exit plan that if something happens to one of you as partners, does that mean you're going to be dealing with a spouse or heirs that don't have the same mission that you have in what you want that business to do for the long term, or you get tied up dealing with somebody that you're like, this is not who I want to operate a business with. Or as we talked about with like the insurance piece, that is part of your succession planning to make sure there is cash flow there to buy those people out or do those things. But even if it's only you solely, you should have that in place. And then we're assigning your LLCs to your trust. And then your trust is going to have the clauses and instructions in there of how your trustee should handle that business succession planning. Because the likelihood is if you're creating this as, this future legacy, you have an opinion about how it's going to go if you're gone. And, sometimes we have kids that say, I don't want to run that family business, or I do, right? It could look so many different ways. So if they don't want to run the business, but they want the income from it, then we have to hire management to do that. But yes, that is always part of all of our design sessions for estate planning in general. We always ask, do you have businesses? What are all those assets? And we talk through that exit plan of what your wishes and desires are of how you want that to function for the long haul. And then we look at it from the LIFT session evaluation as well.
And someone asked this, they already had a will or something, and then they're moving over to a trust. You need both, right?
To have a will and a trust. Yes. However, the type and structure of will that we utilize when you have a trust is a different one than the will we use if you don't have a trust. So you will get a new will, a newly created will, if you are creating a trust and didn't have one before.
Yeah. So your internet will isn't going to hold up very well.
It will not talk to the trust. So the whole way that all of that public nature of probate, like with wills going through probate, the will that we use with a trust is what we call a pour over will. And it's kind of like it sounds. If we left anything out of our wagon, that's going to normally go through probate. So what this will says is if we left anything out of our wagon, that was a mistake. It was not our intention. Our intention was everything should be in the wagon so that we're bypassing this process. So it allows us to pour assets over into a trust. However, you usually cannot do that with real property. So if the real property deed is not in the trust, we have a problem. We're going through probate.
That darn deed, folks, we do need assistance on this. This recently happened, we sold a home that was a mess. And it was because someone tried to do the quit claim deed on their own, put their son on there, and didn't realize what that meant, and it didn't turn out pretty. And so I'm
That
just,
never works.
yeah,
That
I'm just,
is a
the
huge
son had,
no-no.
they just really wanted to pass it, but the way that they did it was not the way. And now it actually prevented the sale, and then it got messy. It's going to
Yeah,
happen. Yeah.
yeah.
But
It's not only just the transfer. When you add someone's name to a deed like that, you're trying to gift it to them or bypass that process. One, it ties their liability and risks, their creditor debtor issues to that property.
that's what happened.
And it also means that you've now gifted something to them with value at a market value. So that is now
Taxes.
income to them that's taxable. And you have gifted, that is a taxable gift to you. So you're paying taxes on the transfer, they're paying taxes on the transfer, and it hasn't bypassed any of the process.
And that was not this person's intention
Of
at
course not.
all.
Of
It
course
was,
not.
if she died, but if didn't happen.
Yep. But if it had been in a trust, they can say, when I die,
Yeah.
they can have it.
Yeah.
It's bypassed the process they were trying to bypass. And it also is fully asset protected for that son, for that beneficiary. So none of their creditors can touch it. You can only do that in a trust.
Yeah. So here's what I want to say is I listened to Sarah's webinar and I learned a few things. And what I know is we all need a checkup. This is kind of like going to the doctor. And I know we don't like to go to the doctor and we don't like to go to the lawyer. But boy, if you are an investor in real estate, you need to get that checkup, or you probably don't have a sound financial plan. You're leaving a mess somehow for yourself, your spouse, or your family somewhere. There's probably something not in the wagon. So tell us, how does this get handled by working with you?
Well, one thing that is fantastic about this, and thanks to LeAnn, I've agreed to be an ongoing resource for you guys. So you can consult me. There is actually no cost to you to get a plan review and an asset review if you would like that. And so the way to do that, or to take advantage of that benefit, is to submit the worksheet that's in the link. And you can check off the boxes that say, yes, I have a plan, I need it reviewed, or no, I don't have a plan, yes, I have business. You'll see all those different things on there. So as we've been talking, if anything triggers your thought process to say, oh, that is something I'm concerned about, check that off on the box so I know we need to talk about it. And then you are able to schedule a 2-hour family wealth planning session. That is normally a $750 fee. That is waived. So I love these. I love doing workshops like this because, it's like I get to be like Oprah, like, you get a plan review and you get a plan review, but you should take advantage of that.
Fill out that worksheet. I just put the link over there again. And when we put this live stream out, we'll always have the link. Fill that out and then make an appointment. And then
Correct.
at least then you'll go over it. And then,
and we'll let you know what's what.
Okay. And then you have options, like they can sign up for A, B, or C.
Yes, there's different plan packages depending on what we determine you need. You'll fit within those, but then we're designing a very specific plan to you. So it's never going to be a one size fits all. It's going to be very specific to your intentions, your values, your concerns, your investment strategies, all the things.
I love that. This is customized, folks. This is not
Yeah.
like buying the little thingy off the internet. This is customized to where you're at in your whole life. Really, this is life planning a lot, around your real estate and all that. So, okay. And that's what I love, that there's some choices, and boy, take advantage of filling out the form. It'll be good for you. We all hate this estate planning stuff, but you have to do it.
I am the first to say it is absolutely ridiculous that I have a job doing this. Like, it should not be this complicated. But as long as we live in this world that we're tied to these rules, then we've got to make sure we're prepared.
Yeah. Wow. And I love the part that, you buy a new property next year or you sell one or whatever. Yes, we have to keep adjusting the wagon.
Yes.
And it sounds like the trust really can help us with that in many, many ways.
Yep.
Okay.
And so
Oh,
we have membership, what we call membership. And so we meet yearly. You get a number of legal documents per year. So most real estate investors use that for quick claim deeds for new properties, getting those into the trust. And we keep an eye on things. So yeah.
yeah, you make sure the paperwork is correct.
Yep.
Okay. Is there any other questions, folks? We are past the hour and let's see. Anything real estate investors should avoid? Like,
Mm. Well, I mean, all good things come in threes, right? So I would say avoid flying by the seat of your pants, assuming you know everything that you need to know or Googling for the answer and assuming it's correct. I know that sounds a little harsh. And doing your own taxes. I am not a tax attorney, but avoid. Small businesses with multiple or individuals with multiple LLCs are a flag for audit. And so doing your own taxes is a pretty big risk. And I think really the message of all of that, if there's like one overall message for this, and again, sounds really harsh, but it's not about you. It's not about you, right? It is about the people you're leaving this legacy for and what you're leaving behind that they have to deal with. And so that's really, I think, when we look at that, going back to that big picture of really saying, what am I leaving behind? Not only I'm trying to create this legacy. So it's worth its weight in gold with that preparation.
totally. And it happened in my family. My brother died and he thought he had something figured out. He swore, it was all planned, whatever, and it wasn't. He had forgotten to sign something.
Mm,
And so now he passes and he had no money for a funeral or anything. And we're all gathering saying, oh boy, well, we get to figure this out. And we did.
hmm.
And it was complicated. And then my sister got hit by a car and that
Oh my
turned into a
gosh.
whole big, I had no idea, we thought she had it together, but then it to her daughter and I had to figure it out and she's all fine now. And we figured it out, but it wasn't easy. And had
Yeah.
there been planning, it would have been easier. And now she has all her ducks in a row because she never wants that to happen to the family again.
Yeah.
So
You
this,
only have to go through it once or talk to
oh
someone who's
yeah,
been
you're
through it,
right.
and you'll never want to do it.
You'll never want to do it again. So I'm going to put up a slide here for everyone that shows how to get in touch with Sarah. Okay. So here she is, beautiful picture.
Oh, thank you.
And this is all of her email, Facebook, everything. So people who watch this can stop the slide and get this all down. Really fill out that form that I'll probably put this right on the slide. I'll put that link for the form too. But
I'm
this
going
is
to
her
post it in
information.
the chat one more time because I know sometimes with Zoom, it's like if you come in
Yeah,
after
you
it's been
lose
posted, you
the
may not be
chat.
able to see it.
Yes. So this is her information and how you can reach her. And then I just need to say my last plug for me. You can do a free strategy session with me or someone on my team here about buy, sell, or invest, or my coaching program that is national and where I help investors figure out how to get started. It's right there. And this is how you can use this QR code, or you can go on my website easily and book a call. And then just want to say, I do have a Facebook group. It's called Real Estate Investing Made Simple. And on there, I do post, what's going on around in the market. It's something you have to know. And I keep you up on there on investor tips also. Now I see there's still something. Okay, good. Sarah's happy to chance. Good thing, Leah. And look at Angela's got the form complete already.
Amazing.
And I know Tim has questions too. So thank you so much for your time and
My pleasure.
all of this education. And I know there's a lot of people who are going to be listening to this because we do put it out to a very wide range. Oh, they want to see the contact slide again. Okay, I'll go back. There you go. Am I on share still? No, I'm showing
I'm
it.
not seeing it now.
Okay, real quick. There. there's the contact slide, but fill out that form. That really is going to help. And if you go to Sarah's website, she's got a pretty good webinar up there too, that, like I said, I learned a lot. So just thank you all for coming today. And
Thank you.
I'll see you next month. And just happy investing. And thank you so much, Sarah.
My pleasure. Bye, everybody.
Goodbye.